he is certified in IPRS and competition laws from IIT Kharagpur with a gold medal. And he is certified in financial risk management from Indian Institute of Management, Bangalore. And he is an UGC net holder in commerce and management. And is an MCOM with finance from Usmania University, Hyderabad, and MBA in finance from Usmania University, Hyderabad. And he holds MPhil degree in development economics from Ambedkar Open University. And he authored one book on entrepreneurial development and edited book on MSMEs. And he contributed chapters in 6 books published by reputed institutions and published 56 research papers in various international journals. And he chaired technical sessions of 5 international seminars and many national conferences. He is presently working as a district nodal officer of NIRF, Medchal district. Previously, he worked as nodal officer for Prime Minister's Yuva program of Mahbub Nagar district and worked as state resource person on behalf of Commissionerate of Collegiate Education, Government of Telangana for pre-NAC assessment of government degree colleges. And presently, he is serving as EC member for Telangana Commerce Association and Indian Accounting Association Hyderabad branch. And presently, he is serving as IQAC coordinator at GDC Kukatpalli, Hyderabad. And he is serving as a member of Board of Studies of 3 autonomous colleges of Telangana. And he worked as convener of faculty forum at MBS Government Arts and Science College. And he is serving as editorial board member for 2 international journals, of which one is listed in UGC CARE. And presently, he is serving in the Government Degree College, Kukatpalli, as mentioned in the earlier sentences. And he served as a master trainer of the district level workshop held on human values and professional ethics. And he delivered 35 extension lectures at various government and aided degree colleges of Telangana, Andhra Pradesh, and Maharashtra. And he served as a resource person in the orientation program conducted by the Board of Intermediate, Government of Telangana, for junior college lecturers. And last but not the least, he served as resource person in orientation programs conducted for degree lecturers by the Social Welfare Department, Government of Telangana. With this brief introduction, I welcome you, sir, wholeheartedly, and I feel proud to have you as a resource person for this state level free online coaching program. Now it's over to you, sir. Thank you very much, sir.
Thank you, Ramesh sir, for presenting my profile.
Thank you,
so, sir. Very good evening to you all. I cannot see how many participants are there owing to my eyesight. And I also beg your pardon for not presenting the PPTs, again owing to my own constraints of eyesight. Despite that, of course, I will not make you unhappy, it's my promise. So, the topic given to me is business laws, which is, of course, a very vast topic. It does not suffice 2 classes to cover the nitty-gritty of syllabus. But today I will try to do something that really matters for your PG set from Contract Act and other conventional laws. And in tomorrow's session, we'll have elaborate lecture on companies law. Friends, you are conversant with your syllabus in business law, that is lion's share is attributed to your Contract Act. Then Sale of Goods Act, followed by your Consumer Protection Act, your IPR laws, and finally Companies Act. Each and every statute itself is an ocean in its own right. So as I told you earlier, that it is not sufficient for me to cover the length and breadth, but I will definitely do the best that really matters for PG set. So let us start with something called Indian Contract Act 1872. So Indian Contract Act 1872, as you would learn in your second semester of BCom, that it is ramified into 2 parts. Part 1 basically deals with the common provisions of the contracts, how to form contract, what really validates contract, what contracts are illegal, so on and so forth. And part 2 deals with the special contracts, namely contract of pledge, contract of agency, contract of guarantee, contract of bailment, contract of surety, right? Fortunately or unfortunately, you don't have special contracts in your syllabus. So today we will be dealing only with the part 1 of Indian Contract Act that starts from section 2 to section 75. So what is section 1 then? Earlier we had section 1 that says Indian Contract Act is applicable to whole of India except to the state of Jammu and Kashmir. But that section is nullified now by virtue of doing away section Article 370. Now all the laws of the country are equally applicable to the state of Jammu and Kashmir either. So it's obvious that Indian Contract Act is also applicable to Jammu and Kashmir, and therefore section 1 has got no validity. Now section 2 prima facie deals with the definitions which are the prime constructs of your entire contract law. If someone asks you what is a contract, so contract is an agreement enforceable by law. Section 2 subsection H, right? So section 2 subsection H has got two important nexus. One is an agreement, another one is its enforceability in the eyes of law. So what is an agreement? Oh, for a simple layman, agreement is an understanding between two persons or few persons to do or not to do something, isn't it? But law will not accept this type of vague definitions. We need concrete definitions based on which judgments are delivered. And by the way, section 2 subsection E of Indian Contract Act defines what is an agreement. See, agreement is every promise and every set of promises forming consideration to each other, right? A promise between two parties or a set of promises between two parties forming consideration to each other. That means forming benefit to each other is called an agreement. That means my obligation shall become your benefit and your obligation shall become my benefit, vice versa. That is the common mode of operating an agreement. If this agreement is legally recognized on the grounds of law, and it is called a contract. But the question is, when an agreement is recognized by the law, what essentials are to be fulfilled in order to make an agreement enforceable in the eyes of law? There are 10 essential elements. If you learn these 10 essential elements, then your contract act is finished. So if all these 10 essential elements are existing in an agreement, it becomes a contract. What are those? Let us understand. See, first there must be two parties, an offerer and offeree. Who is an offerer? An offerer is a person whose brainchild is contract. It is he who initiates the contract. It is he who proposes the contract or an agreement. And to whom you are proposing is called an offeree. So once the agreement is negotiated and finalized between these two parties, the offerer and offeree shall become promisor and promisee respectively. Got my point? You may ask a question, can there be an agreement? Can there be a drafting with a single party, with offerer alone? Yes, can be. Take an example, will. What you call in Telugu, Vilunama. It doesn't require any second party. So a single person can write a will in writing, will on a paper. But it is not a contract. It's only a draft. So contract requires two parties, namely offerer and offeree. Of course, when offerer is there, he must make offer, and offeree is there, he should give his acceptance. So the next point is, there must be lawful offer and lawful acceptance. This lawful acceptance is called promise. See, offer is defined in section 2, subsection A as proposal, and acceptance is defined in section 2, subsection B as promise. We'll come to that later on. So once offer is made, to which other party is giving acceptance, can we call it an enforceable contract? Obviously no, because this should be backed by something called consideration. Consideration means benefit, quid pro quo, something in return. If I am performing my obligation in the agreement, I must get back something in return. It's called a consideration. If I perform something in an agreement without expecting any consideration, it's only a gracious act. It's only a gracious agreement, and it does not constitute contract. So there must be benefit to both the parties. That is called technically consideration, as defined in section 2, subsection D. Right? Next, of course, once offer is made, acceptance is given, consideration is also existing. Is it prima facie sufficient to form a contract? Obviously no. You need to see that both offerer and offeree are competent to form contract. Now, obviously, the question comes, who are competent to form contract? Capacity of the parties to contract. So, you must be a major by age. Who is a major? A person, maybe male or female, completes the age of 18 years under normal circumstances is a major for the purpose of forming contracts. Matrimonial majority age is different again, 18 and 21 for male and female respectively. That will keep aside for time being. We are dealing with Contract Act, so no gender discrimination in contracts. So if you complete 18 years of age under normal circumstances, you are a major. Suppose if parents are died and the boy or girl is being brought up under the custody of a court guardian or custody of a loco parent, like your paternal uncle, maternal uncle, then you will become major only after completion of 21 years, but not 18 years. If both the parents are alive, happy, 18 years are done, you are a major. If parents are deceased and you are under the protection of a court or loco parent, you need to complete the age of 21 years by virtue of section 3 of Indian Majority Act in order to claim the age of majority. So come what may, you must be a major to form a contract. Next, you must be of sound mind. What is this sound mindness? Your mental status should enable you to exercise the prudence on the subject matter of the agreement. Then only you are a sound mind person. So, what are the tests you need to conduct in order to determine the sound mindedness of an individual? One, you must not be a lunatic. What is lunacy? Lunacy is a temporary mental disorder. So long you are suffering with lunacy or you are lunatic, you are not entitled to form any contracts. Once you prove your mental fitness through a medical certificate from competent authorities, then you are entitled to form a contract. Second test is idiocy, that is idiot. So idiot or idiocy is not scolding, my dears, as we see from Telugu cinema heroines in movies. Idiot is one who is suffering with permanent mental disability. Understand? So an idiot cannot enter into any contract in his lifetime because it's a permanent mental disability. And third test you need to conduct in order to see whether a particular person is of sound mind is whether he is intoxicated. For example, I am drunk or I am intoxicated by drugs or narcotics. Under such circumstances, forcefully, if I am induced to sign any agreement and such agreement is not valid, if I can prove in the court that I was drunk when I signed that agreement. Of course, the onus of proof is vested in the hands of challenger all the time. So, conduct these tests, that is lunacy, idiocy, and intoxication, and decide whether you are sound mind or not. So by and large, you must be of sound mind. You must be a major by age. Third, you must not be a convict. That means you are convicted for turpitude of criminal nature or moral nature. Then you are not entitled to form any contract until the completion of your imprisonment plus 6 months after completion of imprisonment. This is called cooling period, right? See, convict is different from an accused, right? Accused is a person on whom allegations are leveled. Convict is a person on whom allegations are proved, right? So, for the simple reason that you are in a jail, you are not a convict. Yeah, Jagan Mohan Reddy was in jail. He's not a convict. But Babu was in jail. He's not a convict. Kejriwal is in jail. Sisodia is in jail. Kavitaji is in jail. They're not convicts. They're only accused. For special reasons, court did not grant them bail. They are in custody. I mean, these persons can enter into valid contract, right? So long Kejriwal is accused, still is in jail, he can be a chief minister. But once guilty is proved, he becomes a convict, then he has to resign the chief ministership. Of course, he will be defenestrated. That is different thing. So I mean to say that you should not be a convict at the time of forming a contract. That is the third test you need to do. Fourth, you must not be a foreign ambassador, right? A foreign ambassador is a person who represents his entire nation abroad. Therefore, foreign ambassadors entering into commercial contracts, business agreements, and fraught with the legal disputes, it's a brutal spot on entire nation. Therefore, what we say is, so long you discharge your duties as a foreign ambassador in India, you are not entitled to form any contract. Similarly, an insolvent, Diwala Koru in Telugu, who is an insolvent, a person whose total assets are less than total liabilities and is formally, that means officially, declared as an insolvent by the court. Similarly, a line enemy. Who is an allied enemy? A person of that nation with which our country formally or officially declares a war is called an allied enemy. So he is also not entitled to form any contracts with us, though you may be a personal friend with him, right? So who are competent to form contracts? You must be a major by age, you must be of sound mind, must not be a convict, must not be an insolvent, must not be a foreign ambassador, must not be an allied enemy. So when I discuss this type of questions, you must be in a position to make out what could be the possible questions in PGCET tomorrow. If I ask a question tomorrow like this in PGCET, who among the following is not competent to form a contract? A, accused. B, convict. C, major. D, only B. Your option should be B, obviously, convict, isn't it? So when accused and convict both are given, you must choose your multiple choice option, MCQ option, as major. So this type of nitty-gritty, you must be in a position to drag or glean from this discussion, because we are only doing the washing process here. We're not going into depth. Chalo bhai, we have two parties. There is offer and acceptance. There is consideration. The capacity of parties to contract is also tested. Then there must be free consent. Free consent is defined in section 14. What is it, free consent? Your acceptance tendered voluntarily. That means when your acceptance, your consent is not subjected to coercion, undue influence, fraud, misrepresentation, and mistake, then only it is called a free consent. What is that free consent? We'll see in the next topic or the next topics to come. After free consent is obtained, there must be consensus ad item between the parties. What is consensus ad item, my dears? In Telugu, we call it as Sarva Sammati.
Identity of minds.
Yeah. Someone want to answer? Please.
Identity of minds.
Wow, wonderful, wonderful.
Same thing in
Ident-
the presence.
Excellent, excellent. So it's an identity of mine. Someone is answering Kirti Kumar. Very good. Very happy for you. So that means both offerer and offeree must understand the subject matter in same sense and in the same manner. That is called consensus ad idem. Clear? So let me take a silly example to illustrate. Don't mistake me. It's only to make the subject easy. So you and your friend want to elope from your town. You ask your friend to come at 10 o'clock. She came at 10 o'clock in the morning and you came at 10 o'clock in the night. What happens? The purpose will not survive. That means there is no consensus ad item. So both the minds must agree upon same thing and in same sense. That is called consensus ad item, my dears. Okay. After obtaining consensus ad item, you must see that the subject matter of the agreement is not specifically declared void under Contract Act. In Contract Act, we have 6 provisions from section 25 to section 30. These are formally declared as void agreements. Such type of agreements should not be there in your proposal. What are those? Section 25. Agreements without consideration are void. Right? There are some exemptions. I will come to that later. Section 26. Agreements in restraint of marital liberty are void. Right? That means what? If any agreement is restricting the liberty of marrying, liberty of marriage is not a valid agreement. Let us take a silly example. One director, he wants to make a movie, Bahubali 3 or 4. So, he makes an agreement with the heroine. You should not marry for the next 3 years. His fear is that if she gets married, she may become pregnant and she cannot act in the movie. But meanwhile, she got married, became pregnant. She said simply, I can't act in the movie. Now the director sues her in the ground of law. I spent crores of rupees to make the sets. So she revoked the agreement. As per Contract Act, I am entitled to compensation. Can this director get compensation? No, because that agreement which restricts the marriage liberty of an individual is invalid. So you must be very meticulous while chalking out such agreements, my dears. Section 26. Section 27. Agreements restricting the trade liberty of others is void. If my agreement is restricting your liberty, your freedom of doing business anywhere, it's forbidden. It's invalid, except in the case of goodwill paid to outgoing partner. We pay goodwill to outgoing partner on super profit basis sometime and request him, you take 3 years super profit and don't do similar business in similar vicinity. It is valid. So in all other cases, restricting the business liberty of someone is not a valid agreement. It's void from the beginning. Clear? That is section 27. 28. Agreements in restraint of legal proceedings. Suppose if I sign an agreement with you, if I and you have a dispute, we should settle it in our Pedarayudu village or Chinnarayudu house. You should not go to court or police station. Is it a valid one? Certainly not. So going to court is my legal proceeding, which your agreement cannot stop, except in the case of arbitration and conciliation. Right? Section, of course, what is arbitration and conciliation? Arbitration is officially recognized way of settling disputes outside the court as far as civil disputes are concerned. Right? Section 29, agreements with uncertainty. That means no proper definition of terms and conditions is invalid. Section 30, betting agreements are invalid. Wagering agreements are invalid. So my intention to say that if any of these contents are there in agreement, it is not a valid contract. The agreement shall not become a contract. Yeah, someone is unmuting. Ramarao garu, any question you have? No. Okay. All right. So, similarly, the terms and conditions of the agreement must be clear. If all these legal essentials are fulfilled, then only agreement becomes a contract. There must be offerer and offeree. There must be lawful offer and acceptance. There must be consideration. there must be lawful object, there must be consensus ad idem, there must be free consent, there must be, there must not be a term which the law specifically declares void, then terms and conditions must be clearly defined, and all other legal formalities which the law stipulates from time to time must duly exist. Only then agreement becomes a contract. So my dears, one question is pakka in your PG set from these essential elements of lawful contract. Now, straight away, let us discuss how many types of contracts are there. I expect 1 or 2 questions from classification of contracts also. So let me allocate some 5 minutes of time to discuss the classification of contracts. I classify contracts on 4 important bases. On the basis of validity, on the basis of formation, please mute yourself, on the basis of execution, and of course, on the basis of British laws. I once again beg your pardon that I am unable to present PPT slides. Had I been in a position to show the flowchart of the classification of contracts, it would be more meaningful for you, but I'm really sorry that my eyesight doesn't permit me for that. So let us see the first classification. Classification of contracts on the basis of validity. Validity means legal recognition. First one here is valid contract. What's a valid contract? Simple. It's an agreement enforceable by law. Tomorrow a question may come in your examination. An agreement enforceable by law is called dash. A valid contract. B, a void contract. C, voidable contract. D, none of these. Your option would be obviously A, valid contract. An agreement which is enforceable by law is called a valid contract. That means everything is proper by, it's recognized by the court whenever dispute comes between the parties, right? Second is void contract. See, more often than not, you may get confused with these 2 terms, or you may overlap these terms, void agreement and void contract. Indeed, they are absolutely different terms. Void agreement is defined in section 2 subsection G, and void contract is defined in section 2 subsection J. Let me explain you what is the difference. According to section 2 subsection G, an agreement void ab initio, that means an agreement not enforceable by law right from the beginning, is called a void agreement. Right from the moment you sign the agreement, it is invalid. Right from the beginning, it is called void ab initio. That means invalid from the beginning. It is called a void agreement. Then what is a void contract? Definition is like this. According to section 2 subsection J, a contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. These British definitions, language is of course a bit difficult, but you have to understand the same way. Ceases means stops. That means a contract which is valid in the beginning but loses validity at a future date is called a void contract. At the time of formation, it's valid, but due to some unforeseen circumstances, such validity is lost. It is called a void contract. But void agreement means right from beginning, it is invalid in the eyes of law. It is called a void agreement. So that is void agreement and void contract. So nonetheless, valid contract is the first one. Second is void contract. Third is voidable contract. What is this voidable contract? It is defined in section 2, subsection I. When contract is enforceable only at the option of one or more of the parties thereto, but not at the option of other or others, is called a voidable contract. Nothing is understood, sir. No problem. Let us decode this definition. Suppose in a contract, one party, he may be promisor or promisee, is aggrieved, is victimized by other party. Such victim will have liberty in the court, either to abide by the contract or to cancel the contract. Only victims. You are victimized because of the opposite party in the contract. You are cheated or deceived by the opposite party in the contract. Then you will have option in the court. If you want, you go ahead with the contract. If you don't want, you can cancel the contract. Such type of contract is called voidable contract. That is the third one. Fourth one is illegal contract. Honestly, the word illegal contract is not defined anywhere in our contract law. But we will presume from section 22 and 23 that the agreement, the subject matter of which is either partially or completely forbidden by any existing law in the country, it is an illegal agreement or illegal contract. Clear? That means the subject matter forming agreement is partially or completely banned or declared to be illegal, then your contract itself is illegal. That is the first classification of contracts, my dears. So on the basis of validity, we have valid contracts, void contracts, voidable contracts, and illegal contracts. So if I set a question paper for PGCET tomorrow, I will definitely ask one question. An agreement not enforceable from the beginning, or an agreement void ab initio is called dash. A, void agreement. B, void contract. C, voidable contract. D, none of this. What would be your option? Obviously, void.
Contract.
Void agreement.
Wide contract.
Wide
No, void agreement. I'm happy like Devi Uma is trying to answer. But my dear, I told you that from the beginning, if it is invalid, it is called void agreement. If it is valid in the beginning and loses validity at a future date, it is called void contract. Okay, very good effort. Right. Now, let us go to second classification of contracts. That is on the basis of formation. Here, we have four types of contracts, my dears. One, expressed contracts. Two, implied contracts. Three, quasi contracts. Four, e-commerce contracts. Honestly, e-commerce contracts also fall in the ambit of expressed contracts because they're also digitally expressed. But our law occasions by virtue of IT Act 2000 to ramify e-commerce contracts as separate contracts. Therefore, this broad classification is brought to fore. Let us see first one, expressed contracts. According to section 9, subsection 2, insofar the contracts formed by words spoken or written is called an expressed contract. Right? Sir, we know that contracts in the written format are valid. But you are telling that even expressed in words spoken also forms a contract. Is it so? Yes, it is. If the words spoken are bolstered by any evidence, it is a valid expressed contract. Suppose you struck a contract or deal with a company through their voice-based call center or BPO, it is a valid contract. Tomorrow you cannot say, no, I did not sign any application form, nor I signed any agreement, so it is not valid. You cannot say like that because your voice, your expression of words is having evidence with the BPO or call center. It is also an expressed contract and valid in the eyes of law by virtue of section 9, subsection 2, which is the reason why call centers and BPOs preserve call data for 2 years as a substantial evidence of transaction. Clear? So be meticulous while talking with these bogus call center fellows and executives. All right. Now, second one is implied contract. What is an implied contract? A contract insofar formed other than by words spoken or written is called an implied contract. Section 9, subsection 1. That means neither with the words spoken nor with the words written, I formed an agreement. It is called implied contract. How can I do that? Through your actions. Suppose I board a public transportation bus and I take a ticket. So my action of taking ticket is a prima facie evidence that I am into contract with the Road Transport Corporation, isn't it? So if I met with an accident, RTC cannot deny compensation for me. No, you did not sign any agreement with us. Need not to sign, because the moment I take ticket, so my action of taking ticket is an implied contract. It's an implication that I am coming into contract with you. So implied contracts are formed through actions, not with the words spoken and not with the words written. They are also valid contracts, right? And third classification we have quasi contracts. What is this quasi contracts? They're also called constructive contracts. Please remember, quasi contracts and constructive contracts are same. If tomorrow he may ask a question, quasi contracts are also known as A, constructive contracts, B, valid contracts, C, void contracts, D, A and B. Then you must say option A and B, both, that is D. So constructive contracts, what these are? In fact, there will not be any agreement or contract between two parties, but law will impose contractual obligations between the parties. It is called a quasi contract. There are 5 types of quasi contracts, section 68 to section 72. So if I go on giving case laws and explanations to all these quasi contracts, even 1 hour will not suffice, but they are very important. So let us scroll it for a minute and go ahead. 1, section 68. Necessities supplied to minor are quasi-contractual obligations to pay. Suppose a minor is not entitled to form any contract. You and I know that. But I am supplying him some necessities like food, clothing, shelter, education. Then it can be recovered from his estate as my quasi-contractual right. He cannot deny that it's quasi-contractual obligation for him. So there is no contract between minor and me. But I have a right by virtue of section 68 to recover my expenses. That is quasi-contract under section 68. Section 69, reimbursement of the payment made in good faith to save the property of others. Right? Suppose I am making some payment to save your property from endanger or from damage. Then I have a right to recover such expenditure from you or from the landlord or from the owner of the property. You cannot say, no, there is no such contract that my property will be in danger. You pay the money, later on I will pay you. Such contract is not there, so I will not pay any money. You cannot say like that, because section 69 clearly says, once I come forward to rescue your property, then I have every right to recover it under quasi-contractual obligation. Similarly, section 70, responsibility of a person enjoying gracious benefit. That means benefit is not meant at my disposal. Still I am enjoying it. Then don't you think I have obligation to restore the same for actual beneficiary? Certainly yes. So I cannot say no. There is no contract between me and actual beneficiary. I don't reimburse. You cannot say like that. Once I am enjoying the property to which I am not a beneficiary, then it is my quasi-contractual obligation under section 70 to reimburse the same to other person, that is other beneficiary, the actual beneficiary. That is section 70. Section 71, responsibility of finder of goods. If you find some goods, your position is as good as that of a bailee. That means you can retain the goods with you, but you cannot sell them. That's your responsibility. You have to retain the goods with you and put reasonable efforts to trace the genuine owner. And of course, whatever expenditure is incurred to trace the genuine owner, that can be recovered under quasi-contractual obligation. You may ask a question, sir, I was taking a morning walk and I found some diamond ring on the road. So can I retain it with me? Yes, of course, you can retain it with you. Sir, I need not to go to police station. Technically, you need not to go to police station. But our public policy, our ethical policy of the state occasions you to report to police station. Because what I told you, you are the owner of the goods found against rest of the world except to the true owner. You can retain the goods until true owner is traced. Clear? That is section 71. 72. Responsibility of a person to restore the benefit if voidable contracts are set aside. So what is a voidable contract? Just now we have discussed. Can anyone unmute and help me? What is a voidable contract, my dears? Kirti, Uma, Kirti Kumar, someone, anyone?
Enforceable
Yeah, loudly.
contract.
No.
When it ceases to enforceable.
Nana? When it is ceases to be enforceable, it's called a void contract. No. When it is ceases to
Voidable
be
means when it is voidable at the option of one party. If he
Wonderful. Kirti Kumar is
to
absolutely
avoid,
correct.
then he can avoid. If he wants to continue the contract, he can continue the contract.
Absolutely. You're spot on, my dear. Correct. Absolutely correct. Very proud of you. I told you just now that in a contract, one party is a victim. He is a cheated. So he will have liberty either to go ahead with the contract or to cancel the contract. It is called voidable contract. Clear? Now, in quasi contracts, what section 72 says is that in such voidable contract, if the victimized person decides to cancel the contract, then the other party must restore whatever benefit he took in the contract to the victim. Clear? That is called section 72 quasi-contractual obligations. Clear? 68. Necessity supplied to minor. 69. Reimbursement of the payment made to save the property of others. 70. Enjoying non-gracious benefit to restore the same to actual beneficiary. 71. Responsibility of finder of goods. 72. Responsibility to restore the benefit when voidable contract is set aside. These 5 are called quasi contracts. Or someone can help me? Or
Constructive contract.
wow, wonderful. Constructive contracts. Clear. So you're all following me. I'm very happy. This is second classification. Of course, after quasi contracts, we have e-commerce contracts. It is nothing but contracts signed in digital format with e-commerce applicants. It's called a e-commerce contract. What is commerce? First of all, commerce is a facilitation of trade. For example, Amazon, Myntra, Flipkart, you have Zepto, so many mobile apps, no? They're all e-commerce apps. What they're doing? They are facilitating the buying and selling process. So, if I have an agreement with this type of e-commerce platforms, it's called an e-commerce contract in the digital format. Clear?
Yes, sir.
Yeah. So, all right. So, this second classification. First classification on the basis of validity. Second classification on the basis of formation. Now, third classification on the basis of execution, on the basis of work done in the contract. Here, yeah. Amma Sangeeta, you please mute yourself, Betty. I'm getting disturbance. All right. Now, third classification on the basis of execution or work done. Here, we have executed contract, executory contracts, unilateral contracts, bilateral contracts. Let us understand. What is an executed contract? A contract where the obligations of both the parties is completed. Both offerer and offeree have duly performed their obligations. The contract is finished. It is called executed contract or past contract. Right? Second is executory contract. That means only an agreement is made and yet the work is not begun. It is called executory contract. That means only agreement is signed. Both offerer and offeree have to come forward. Promisor and promisee have to come forward and do the work at a future date. Just agreement is made. It is called executory contract. Third is unilateral contract. The name itself indicates, my dears, contract where one party has discharged his obligation and the other party is yet to perform the obligation. is called unilateral contract. Only one party has performed the obligation in the agreement. Other party is yet to do. It's called unilateral agreement. And what is bilateral agreement? Where both the parties are yet to perform the obligations is called a bilateral contract. Then you may ask a question, sir, what is the difference between executory contract and bilateral contract? They both same for me. In executory contract also work is yet to be tendered. In bilateral contract is also work is yet to be tendered. What is the difference then? Difference could be this. In executory contract, work done is nothing. Work in progress is nothing. But in bilateral contract, there could be some work in progress from both the sides. That means both the sides have partially performed and both the sides have to yet perform the obligations. It is called bilateral contract. Getting my point? This is the third classification. And fourth classification is on the basis of British law. Here we have two types, simple contracts and formal contracts. Simple contracts are nothing but normal business contracts. Agreement to sell the house, agreement to sell the vehicle, so agreement to sell the goods, so on and so forth. There are simple contracts. And what are the formal contracts? Formal contracts are of two types, where courts and governments are involved. One, contract under record. Two, contract under seal. What is this contract under record? In London, that is in UK, court judgments in the case of civil dispute is called a contract under record. That means both the parties will be forced to sign the agreement that they will abide by the judgment in the case of civil disputes. So civil dispute judgment in London is called a contract under record. But in India, we call judgment only. There's nothing called contract under record here. Though the genesis of Indian law owes its etymology to British laws. Second is contract under seal. If any contract which is subjected to government attestation or government vetting, it is called a contract under seal. Simply, a contract where government is a party is called contract under seal. So this is the classification of contracts. Got my point? So first we have seen the essential elements of lawful contract. Then we understood the classification of contracts. Among these two topics, mark my words, at least 2 questions will come for your main, PGCET examination. Now, time is still there. It's still 6:49. So let us go to the next topics. I told you the essential elements of lawful offer, lawful contract, like offer, acceptance, consideration, free consent, etc. Let us discuss one by one in detail now, because some questions you may expect in PGCET from this. Let us first take offer. Then we'll go for acceptance. What is meant by offer? It's a proposal, isn't it? So, according to section 2, subsection A, when one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of such another, is said to have made an offer. Nothing is understood, sir. Don't get confused with the definitions. I will decode them. So why definitions are very important in law? Based on the definitions only, judgments are delivered. Good and bad are decided. I will give a simple example. Don't write anywhere in the examinations. Just remember for understanding purpose. In 1994, when NTR became chief minister on the premise of Madhyapana Nishedam, that is prohibition on liquor, so they made an agreement. The agreement was very loose. They made a GO. GO was very simple and loose. It said selling or consuming alcohol in the state of Andhra Pradesh is prohibited with effect from 1st June 1994. That was the agreement. What was that? That was the GO. So selling and consuming liquor is prohibited. Simple GO. There was one guy, Vijay Mallya, who of course now absconding, kept on manufacturing the beer and liquor in his Nacharam plant of Hyderabad. UB plant is there in Nacharam. Now it is shifted to Sadashivpet. Then excise department roared the plant and seized it. There is a prohibition. Still you are manufacturing the liquor here. Then he went to court. What is wrong with me? I did not violate any laws here. Do you think that the claim of Vijay Mallya is correct? Yes, he was right back then. Look at the GO. What did you write in government order? Selling and consuming alcohol is banned. Am I selling here? No. Am I consuming here? No. I'm simply manufacturing here. Oh, sorry, boss, you are right. So definition is loose, unclear. Therefore, Vijay Mallya could escape the punishment back then in 1994. Then immediately government rectified the GO. It came like this, a lengthy definition. Producing, processing, alcohol, its beverages, its byproducts, other than from medicinal purposes, its consumption, sale, distribution, directly or indirectly, is prohibited strictly in the state of Andhra Pradesh. Lengthy definition has come. Now he cannot manufacture liquor here. Got my point? So if definitions are unclear, the persons who are involving in that, the stakeholders using the definitions will go scot-free, will escape the punishment. So that is the reason why we define offer also very clearly in section 2, subsection A like this. No doubt for a common man, offer delvara sir, offer is a mere proposal to do or not to do something. So we say offer when one person signifies to another his willingness to do or to abstain from doing. That means stop from doing anything with the intent to obtaining the assent of such other. Why you make offer? To obtain the acceptance of other. That's the intention, isn't it? So such act is called offer. You may ask a question, sir, to do a particular work, you make offer. Not to do a particular work, why the hell you should make offer, sir? Any justification for that, sir? Let us suppose like this. I will give you super profits of 3 years as a goodwill. And you should not do similar business for 1 year here. So you should not do business here for 1 year, for which I will give you super profit goodwill. So I am asking you not to do a particular work here. That is my offer, isn't it? It is also valid. It's also valid. So you may make offer not only to do a particular work. You can also make an offer making a person not to do some particular activity. That's a definition, very clear in it. So how many types of offers are there? There are 5 types of offers, namely general offer, special offer, crossed offers, counter offers, and tenders as offers. Right? Now, general offer. An offer made to public at large is called a general offer, to which anyone can give their acceptance. Hope you all remember Cargill versus Carbolic Smoke Ball Company. I don't have time now to dwell into that case, but general offer is one which is made to public at large, to which everyone can give their acceptance. Special offer, on the other hand, offer made to specific person. Others cannot give their acceptance. Cross offers means when 2 same offers are exchanged in ignorance, they are called cross offers. They are invalid in the eyes of law. For example, I am making a letter to you, in the offer letter to you. Will you sell your house for 1 crore? You don't know that I am writing a letter. You also wrote a letter to me. Will you buy my house for 1 crore? Don't you think content is same? I am making offer. Will you sell your house? You are asking, will you buy my house? There's no acceptance. Yes, I will buy your house, isn't it? So 2 same offers are exchanged between parties in ignorance. They are called cross offers. So therefore, there is no contract. Cross offers are invalid in the eyes of law. Next, of course, we have counter offers, right? Counter offer means if offer is encountered with another offer, it is called a counter offer. If I make an offer, will you buy my house for 1 crore? If you say yes, it's a contract. But you are not saying yes. You are saying yes. Like this. Yes, I will buy your house for 1 crore, provided you buy my chicken shop in Nacharam for 10 lakhs. So what is it you are doing? You are encountering my offer with another offer. Or you are giving a conditional acceptance. You are putting a condition in the acceptance and giving it to me. So it is also invalid in the eyes of law, my dears. So conditional acceptance leads to dash. A, promise. B, general offer. C, tender. D, counter offer. What's your answer? Counter offer, because offer must be unconditional. If you put a condition in the acceptance, then it is called a counter offer. One offer is encountered with another offer. Then, of course, we have tender. Tender is also a type of offer, but submitted in response to invitation to offer. Right? For example, someone is inviting, we want to construct a flyover, we want to construct a railway bridge. Interested parties, please submit your offers in the form of tenders. So contractor A submits, I will do it for 1 crore. Contractor B says, I will do it for 90 lakhs. So they are making offers. Then whoever quotes lowest price, to that person I am going to give acceptance. So tender is also an offer, but submitted in response to invitation to offer. There are 2 types, standing tender and specific tender. Forget about that. It's not our platform to discuss now that. Now, what are the conditions of offer? Why you say that cross offers and counter offers are invalid in the eyes of law? Because they do not fulfill the essential elements of lawful offer. Obviously, the question comes, what are the essential elements of lawful offer? What are those? Number 1, it must be capable of creating lawful relation. For example, wife and husband have an agreement. Let us live in separate house. I will give you every month 10,000 rupees or 20,000 rupees. Husband made a promise. Wife said, okay, happy. But after 1 month or 2 months, husband did not give money to wife. Can she go to court and claim the money? Can she? Anyone unmute and answer? Husband made a promise to wife. Yeah?
No.
Yes, sir.
No is the right answer. Uma is right. Why no? Because wife and husband relation is a social relation. If you have problem, you must apply for divorce and claim for maintenance through other act, not through contract act. So there must be contractual relation between the parties. That's promise relation that comes into picture only when offer, acceptance, consideration, free consent, everything is there. But in this example, consideration is not there for husband. Benefit is not given to husband. Only for wife benefit is granted. So it is not capable of creating lawful relation. Offer must be capable of creating lawful relation. Second, offer can be general or special. Offer can be conditional. Remember, you can put conditions in offer, but acceptance cannot be conditional. If you give conditional acceptance, it becomes a counter offer. So offer can be conditional, but not acceptance. Offer must be communicated to offeree. It must come to the knowledge of the offeree, the person to whom you are making offer. Offer must be distinguished from invitation to offer. Mere price declaration is not an offer. Only declaring price of a product does not constitute offer, my dears. Once price is declared, it is meant for invitation. It's not an offer. Clear? So these are the essential elements of lawful offer and types of offer. Now, let us go to, we'll make it fast. Sir, can I go ahead beyond 7 o'clock also? Naresh, sir?
Yes, sir. Yes.
Yeah, thank you, sir.
Take your own time.
I'll consume some more time. Right.
Okay,
Now,
sir. No problem.
let us see acceptance or promise. What is this promise? According to section 2, subsection B, when the person to whom offer is made signifies his assent thereto, the offer becomes a promise. That means to whom you made offer is unconditionally saying yes, then offer becomes a promise. That's acceptance. So how many essential elements you need to fulfill? Suppose someone is putting a revolver in the point blank range and asking you to sign the agreement. You signed it. Is it a valid acceptance? No. Then why cinemas are showing like that? No, kada. So why cinemas are showing like that? Villain Rao Gopal Rao forces the heroine to sign the agreement. She signs the agreement. Meanwhile, hero jumps from the waterfalls, rescues that heroine, and tears the agreement. Why so much of drama? It is invalid if you prove in the eyes of the law that it is a acceptance given under force. It's not a free acceptance. It is a movie by, but in reality, acceptance must fulfill certain essential elements. Only then it constitutes an agreement. What are those? Number one, it must be free and genuine. It must be unconditional. If you put conditions, it becomes a counteroffer, not an acceptance. It must be communicated to offerer, to whom you are giving your acceptance. It must reach him. It must be in the mode prescribed by the offerer. Whatever mode he prescribes, through email, telegram, whatever mode he is prescribing, that you have to scrupulously follow. Next, it must be given within specified time if time is so stipulated. Acceptance must not be implied from silence. Acceptance, of course, can be expressed or implied. Just now we discussed in chapter 1 of classification of contracts. It can be expressed contract or implied contract. And so is the case with your acceptance either. That means you can express your acceptance in words spoken or written, or you can communicate your acceptance through implied actions. So these are the essential elements of acceptance, right? Now, after offer and acceptance, let us straight away go to consideration. What is consideration? It is a benefit. Yeah, very good. Someone is answering. I'm happy. It's a benefit designed in the agreement or contract. So without consideration, contracts are invalid in the eyes of law. They're void agreements. Section 25, right? So which section of Indian Contract Act invalidates contracts without a consideration? Section 25, right? You must remember this. So consideration is the benefit which I derive by performing my contractual obligation. But definition is not like this. Definition is again very headache process. It is like this. According to section 2, subsection D, when at the desire of the promisor, the promisee or any other person has done or abstained from doing, does or abstain from doing, or promises to do or to abstain from doing something, such act, abstinence or forbearance forms consideration to contract. Very lengthy definition. Not understood, sir. Let us decode this definition. Consideration must move at the desire of promisor. Hope you learned Durga Prasad versus Baldev case from your second semester. Whoever is the offerer, as per his desire, as per his wish of the offerer, consideration must be designed. Right? Consideration can be enforced by promisee or any other person. But when? If such other person is the beneficiary of contract. Third person can also demand consideration in the contract, provided such third person is a beneficiary in the contract. Third, it can be past, present, or future. Fourth, it need not be adequate, but it should be real. If you want to sell your 1 crore rupees house for 1 lakh rupees, you can do it. So it's a valid contract. But if you want to sell your 1 crore rupees at free of cost, it is not a contract. There must be some real, some materialistic value of amount in the eyes of law. Consideration need not be adequate, but should be real. Consideration is not an illusion. It should not be a myth, right? For example, one case law is there, Umadat Pandey versus Manu Singh. In that case, one spiritual teacher, Bogus Baba, forces his student, his follower, you transfer your property to my ashram, my spiritual school, I will grant you salvation, moksham. The poor student transferred the property. Later on, he realized that it's a cheating activity. He went to court. Then the Baba's lawyer argued in the court, no, we granted salvation, moksham, to our devotee. That's a benefit to him. That's a consideration to him, right? Moksham, salvation, tamarind pickle, all these things are not accepted by the court, my dears. there should be some measurable, quantifiable benefit. Only it is called consideration. So in this case, Supreme Court clearly said that there is no consideration, no benefit for the person who transferred the house to school. So therefore, it's an invalid contract. He can claim back the property, right? So consideration should not be illusion. And consideration should not be something which the party is legally bound to do. Suppose you ask your friend, "Are bhai, come to court and give the genuine witness." You need not to give any fake witness. You give genuine witness. I will offer you some amount. Did that, but you did not pay any money. Can he go to court on you? He cannot, because giving genuine witness in the court is a legal duty for which no consideration to be paid. So you need not to keep your promise. So these are the essential elements you need to remember in consideration. It is also called quid pro quo, something in return. Clear? So without consideration, generally contracts are invalid. But only under 5 or 6 circumstances, agreements are valid even in the absence of consideration. When, sir? When agreements are made with natural love and affection and duly registered as a will. Suppose a father is dying. He said, Liar Garu, I want to transfer entire property to my daughter. Write a will, Vilunama. So, though daughter is not paying a single rupee to father, it is a valid agreement. So, agreements made with natural love and affection and duly registered as a will are enforceable even without consideration. Second, promise made for compensating the services rendered in the past. Suppose suddenly government stops giving pension to employees, retired employees. It says, why should we pay pension now? It cannot say like that, because it's a promise you made already, right? That you did some services in the past, we make you compensation as a pension, for which no consideration, no work is expected from the employee. Third, promise made to repay the time-bar debt, also enforceable without consideration. Promise made to give any gifts or lotteries, also require no consideration. Promise made for charitable subscriptions also requires no consideration, provided any materialistic expenditure is incurred at the strength of your promise. And finally, no consideration is required to create contract of agency, right? Now, I may ask a question like this in PGCET tomorrow. Which of the following agreements or which of the following contracts does not require any consideration? A, contract of bailment. B, contract of pledge. C, contract of agency. D, none of this. Your answer should be C, contract of agency. You can appoint agent without paying a single rupee of commission if other party is accepting to act as your agent. Clear? So this is all about consideration. Now, capacity of the parties to contract we have already dealt. You must be major by age. You must be of sound mind. You must not be a foreign ambassador. You must not be a convict. You must not be insolvent. And you must not be an aligned enemy of the nation. So I will skip this chapter here because time is not sufficient for me. Now, straight away, I will go to the other topic, that is free consent. What is free consent? Consent which is free from coercion, undue influence, fraud, misrepresentation, and mistake. If any of these 5 are there in the consent which you are giving, it is not a free consent. It will not form any valid agreement. Coercion means forceful act, blackmailing act. Section 15 has given beautiful definition and wonderful case laws are there, like Chikkam Amiraju versus Chikkam Seshamma, Ranganayakama versus Alvar Shetty. These are very antique case laws that really took place in Indian Supreme Court, but I'm unfortunately not in a position to discuss them here owing to the paucity of time. But when time permits, you please read them, right? So when any blackmailing act or forceful act is there, it's a coercion. And if you are giving your acceptance, it is not a free consent. Next is undue influence. What is this undue influence? See, there are 2 parties such that there's a relation between them, like doctor-patient, teacher-student, parent to son. So some relation is there. One party is in a dominating position, other party is in a weak position, and the dominating person is misusing that relation to take advantage. It is called undue influence. For example, a doctor knows that a particular disease can be cured with medicines. Surgery is not required, but he is threatening the patient. Arey, potavara, surgery is required. Poor patient will listen. So it's undue influence, misusing it, isn't it? So undue influence is there. It is not a valid contract, my dear. It's not a free consent. Fraud. If you do any fraudulent act and obtain the consent as defined in section 17 of Contract Act, it is not a free consent. Misrepresentation. That means innocently you are wrongfully representing the false as a truth. It is called misrepresentation. Then also it is not a free consent. Mistake, some error you are committing in the agreement or consent, it is also not a free consent. Simply you remember for your PGCET purpose that any consent which is subjected to either coercion or undue influence or fraud or misrepresentation or mistake is not a free consent. If any of these 5 are there in the consent, it is not a free consent. Section 14. Clear? Now, I will skip contingent contract and performance of contracts here. They are not so important for examination purpose, that is PGCET purpose. So, simply contingent contract, what is a contract? A contract to do or not to do something if some event collateral to such contract does or does not happen is a contingent contract. For example, I take an insurance policy for my bike. So that's a contract between me and my insurance company. When does the obligation of insurance company comes into picture? Only when my bike is met with the accident or some contingency happens. Otherwise, contract is not enforceable. It is called a contingent contract. Simply remember this much for PGCET. It is sufficient on contingent contracts. It deals from section 31 to 36. Now, from section 37 to 62, we have performance of contracts, which I'm skipping here. It will not come for examination, I mean PGCET purpose. Straight away, I will go to the next 2 topics with which Contract Act will be completely done. One is breach of contract and remedies for breach of contract. Sorry. Right. So, how can you discharge contract first of all? By performance. If you perform the contract, it is discharged. Number 2, by agreement. There can be 6 types of agreements between the parties to terminate the existing contract. One is novation. What is novation? Can anyone unmute and answer me? Novation. No idea, sir. We forgot it long ago. No problem. Novation is the process of replacing old contract with new contract. It is called a novation. So it's also one way of discharging the existing contract. Similarly, remission, that is accepting lesser performance. Rescission, cancelling the performance altogether. Waiver, forgiving the party from performing the contract. Alteration, changing the terms and conditions. Merger, clubbing 2 or more agreements into one agreement. So this type of agreements you can have, that is novation, remission, rescission, alteration, waiver, and merger to discharge your contract by agreement. Third is supervening impossibility. What is supervening impossibility? The act which is capable of performance in the beginning but becomes impossible at a future date is called supervening impossibility. Then also contract is discharged. Of course, sometimes supervening impossibility is not a valid excuse and sometimes it is a valid excuse. But at this juncture, for the purpose of PGCET, you remember that an act which is capable of performance in the beginning and becomes impossible at a future date is called a supervening impossibility. Next, of course, change of law. Suddenly law is changed. Contract is terminated. Lapse of time. The time given in the agreement is also lapsed. Then also contract can be terminated. And finally, breach of contract. That means when you are intentionally not performing the contract, it is called revocation of contract or breach of contract. So this is the problem. When you intentionally don't perform the contract or breach the contract, the other party should have some remedies, some benefits in the eyes of law. That's our last topic in Contract Act Part 1. Remedies for breach of contract. And contract is revoked. What are the benefits you have? What are the remedies you have? One, you can suit for cancellation. When contract is of big size, other party is not intentionally performing it, you can go to court and apply for canceling the contract. That is suit for cancellation. Number two, suit for damages. There are 7 types of damages, my dear. I will not tell you here. Time is not sufficient. Ordinary damages, special damages, liquidated damages, vindictive damages, remote damages, nominal damages, and damages of reputation. You please go through the 7 types of damages at your leisure time. Just I am giving you a hint that there are 7 types of damages, either of which you can claim, except nominal damages and remote damages, right? Third is suit for specific performance. When the breaking of contract or revoking of contract is of such a nature, the compensation cannot be claimed in terms of money. Then we may request the court, sir, ask him to perform the contract. I don't want any money. It's called suit for specific performance. And suit for quantum merit. It is very, very important bit for your PGCET, my dears. What is quantum merit? MERUIT. It's not English word, don't worry. Quantum merit stands for as much as earned. Chalo bhai, you have performed partially the contract and revoked it. So whatever benefit you have earned so far in the contract, that you restore it to me as a remedy. That is called suit for quantum merit. And finally, suit for injunction. It is also called stay order. Sir, he is not performing the contract. Other parties say, no, sir, he is not performing the contract. Then court says, no, stay order is issued. Both the parties stay there only. Don't go ahead. We will decide who is wrong, who is right. Then remedy can be decided. That is called suit for injunction. So this type of 5 remedies you have if other party is revoking the contract or breaching the contract. Suit for rescission of the contract, suit for damages, suit for specific performance, suit for quantum merit, and suit for injunction. And my dear children, with this part 1 of Indian Contract Act is over. Now, of course, you have Sale of Goods Act, Consumer Protection Act, and IPRs. I require many classes for that, but simply you remember the year in which these acts are made. In which year Sale of Goods Act is made? 1930, right? Similarly, you remember few things. Who is an unpaid seller? Similarly, what is the difference between guarantee and warranty, right? Similarly, what is the difference between sale and agreement to sell? To the best of my knowledge, he will ask you a question on the year, in which year Sale of Goods Act is made, 1930. He will give a question. If the buyer has got a right to cancel the contract of sale, what type of right he has got? It's a guarantee. If it is only warranty, I cannot cancel the contract of sale. I can simply claim damages or replace the goods, isn't it? Similarly, what is goods? It's movable property other than money and actionable claims as defined in Section 2, subsection 7 of the Sale of Goods Act. This much you remember on Sale of Goods Act, it is sufficient. When you go to Consumer Act, Consumer Protection Act 1986. So now we have latest Consumer Act, right? Consumer Protection Act 2019. But this act is not completely implemented now. So as of now, for your PGCET, old Consumer Protection Act 1986 will be considered. So here you remember the composition of consumer forums. At district forum, how many members should be there? 3 members. At state forum, how many members should be there? 3 members. At national forum or national commission, how many members should be there? 5 members. Similarly, what is the amount limit for district forum? 10 lakhs in old act, 1 crore, between 10 lakhs and 1 crore in state forum, more than 1 crore in national forum. I am talking about the old act, which comes for your PGCET purpose. New act, it's different again. And you also try to learn who is a consumer. There's a difference between buyer and consumer. The difference between customer and consumer that you have to remember. This much is sufficient in Consumer Protection Act 1986. When we go for IPRs, my dears, you learn basic things from 3 acts: patents, copyrights, and trademarks. 1 or 2 questions he may ask you on geographical indicators. Main Patents Act, in which year it has come? 1970. Copyrights Act, in which year it has come? 1957. Trademarks Act, in which year it has come? 1999. Isn't it? Then the intellectual property granted for innovation is called dash. Can anyone help me? Unmute and answer. What type of intellectual property right you will get for innovation? A, patent. B, copyright. C, trademark. D, GI. Anyone can answer?
Copyrights.
Copyright? No. For innovations.
Patents.
Patent. Patent is the right answer. Who is answering? Ritvik. Ritvik answered right. So for innovations, you will get patent as a intellectual property protection. This type of questions will come in the PGCET examination. So for literature, see, patents are granted for inventions or innovations. For how many years patents are granted? 20 years. Earlier, in previous law, product patents are granted only for 15 years, process patents for 5 years. But now, no such discrimination. Once you obtain a patent for your innovation, it is protected for 20 years. That much you remember for PGCET. Copyright. So, what type of creative work you will get copyright? There are 6 categories of work for which intellectual properties are granted in the form of copyrights, namely literature, music, art, cinematography, computer software, and sound recording. So for these 6 categories, the IPR which is granted to you is called a copyright. Right? For example, I am making a movie. What type of IPR I will get? Patent or copyright? Copyright.
Copyright.
Very good. Right, very good. Similarly, trademark. So trademarks are nothing but the brand names of the products or services. I love this topic indeed, Trademarks Act 1999, but time is not sufficient now. Simply remember that surnames, only surnames are not given as trademarks. What are that you're talking, sir? All the famous brands, trademarks in this country are surnames only. Tata, Bajaj, Birla. How can you say that surnames are not given as trademarks, sir? Are you cheating us? No, my dears. Only surnames will not be given as trademarks. If you have any suffix or prefix, some additional word before or after the surname, that you can take as a trademark. Can you show Tata car anywhere? You cannot. You can show only Tata Nexon, Tata Indica, Tata Safari, Tata Harrier, so on and so forth. Only Tata will not be a trademark, which is surname. Can you show me Birla brand name or only Bajaj scooter or Bajaj bike? No. Bajaj Pulsar, Bajaj TTSI. So some words you add after your surname, then it can be taken as a trademark. Trademarks in this country are protected for 10 years. Under Trademarks Act 1999, trademarks are divided into 34 classes. This much you remember for PGCET. If you give me 1 more hour, I can dwell more into Trademarks Act. Now forget about it. So similarly, geographical indicators. As a student of Telangana, I am always proud that the first geographical indicator of India is from our Telangana. That is Pochampalli Sari. Right? So if you Google that, in Wikipedia, someone has given wrong information. Someone has uploaded the wrong information. That Darjeeling tea is the first trademark in India. No, absolute lie, blatant mistake. The first trademark in India is obtained in 2007 when Y.S. Rajshekar Reddy was the chief minister for Pochampalli Sari. That means if any seller in a shop is saying it's a Pochampalli Sari, it should have been woven only at Pochampalli, nowhere else. That's the meaning of geographical indicator. Clear? So these are the IPRs you remember mainly: Patents Act, Trademarks Act, Copyrights Act. Okay. So with this, entire syllabus of business law except Companies Act is partially dealt. I beg your pardon, it's only partially dealt owing to time constraints. So tomorrow at 6 o'clock, you please sharp join. We will focus much on Companies Act, how companies are formed, what are the types of companies, who are the directors, types of directors, how many types of meetings are conducted in the companies, how to winding up of company, everything I will discuss, which is useful not only for your PG purpose, but also for your MBA or CA, CS, whatever course you do, this literature will come to you, right? So, Naresh sir, I am done for today. Over to you.
Okay, sir. Thank you very much, sir, for your valuable information regarding the business, sir. Thank you very much, sir. So we will see you tomorrow at the same time.
Thank you, sir.